Good morning, good afternoon, happy 4th of July. Not legal advice, KNOT. Like, subscribe, share, comment, whatever. Enjoy your 4th and be safe. Today's joke, or I'll call it a joke, all chemists know that alcohol is always a solution. Anyway, today we're going to talk about there was a writ of certiorari that was granted by the U.S. Supreme Court. So if you have a case and you want the court to hear it, there's some statutes or issues that might have direct appeal to the U.S. Supreme Court. But most times you're just asking for it to exercise its discretion and consider a case. So recently they accepted a case for consideration. The name of the case is, and I may mispronounce it, is Jarkesy, Jaresky versus SEC. And it's basically a case before the Supreme Court, will be a case before the Supreme Court that is designed to test whether there should be a restriction of SEC and FINRA powers, regulatory powers in essence. So since the Supreme Court just granted cert, as we call it in the legal profession, and only a very limited number of attorneys argue cases before the U.S. Supreme Court, not I, but there are a group of attorneys that do. This means the case will be considered sometime during the next term, and that term starts the first week of October, and so that means that this case will be decided sometime before summer of 2024. Could be earlier, but sometime between October and summer of 2024, there'll be a ruling issued in this case. So the basic issue specifically is whether the SEC's authority, where there is a securities fraud claim that seeks civil penalties, what is their authority? And I reviewed the lengthy decision of the Fifth Circuit Court of Appeals, which I think is dated May of 2022, on this matter. And after a cursory review of the opinion, this is my initial read. So I kind of looked through it, had a couple of discussions with a couple of people, but I haven't read it deeply and multiple times, which I will do. But I haven't. So this is kind of my first look at first blush and with discussion. So the basic idea was the SEC brought an enforcement action against Jarkesy and others. Jarkesy had set up a hedge fund, got investors, and had raised $24 million. Apparently things didn't go well, so the SEC started an enforcement action and found fraud, which was affirmed. And part of the issue was that they had misvalued, Jarkesy, or whatever their name, had misvalued assets, and their fees were based upon the amount of the value of the assets. So they were, in essence, misappropriating monies. They also had made some misstatements around auditors and other things. So there was a bunch of series of things. SEC started an enforcement action. There were some odd things that went on during the enforcement action, but the SEC pursued an action before the SEC and before an administrative law judge, the SEC, and then that was appealed, and they both found against Jarkesy and his crew. They ordered a bunch of relief, some of it equitable, but some of it was directly monetary. So they did order like a cease and desist order, but they did order a civil penalty of $300,000 around, and also ordered that they disgorge $685,000. So that in essence they had to give back the $685,000 that they had made. But it was the civil penalty that became the issue. So the court this is now the Fifth Circuit, when they were examining it, they found that the enforcement proceedings were similar to a common law fraud trial, that just because there was a public benefit, that does not negate the right to a jury trial. Fraud was a common law claim, and as such, they found, and I'll address it again a little later, but they found there was a right to a jury trial per the Seventh Amendment of the Constitution. There also was a claim that there was improper delegation from Congress to the SEC to handle these matters, And the basic assertion was there was no guidance, and without guidance, that the delegation was improper. There was also a third, very narrow ground, constitutional ground, that was asserted, but at this point in time, I think it's more confusing than helpful for this basic discussion, so I'm not going to take it up with you. So the issues that are on appeal to the U.S. Supreme Court, will this, and there are issues that are going to be addressed by the U.S. Supreme Court, and kind of my questions will be, will this impact SEC's ability from conducting further enforcement actions against either brokers, hedge funds, or others who are involved, who are charged with securities fraud? Will this roll down to FINRA as they flow from the SEC? So to the extent there's a claim there's a improper delegation from Congress to the SEC, that would seemingly roll down to FINRA. So is FINRA acting without proper constitutional authority? And if so, do they have a power to continue to act? And I'll assert one additional thing that might be interesting. There's also reference in the opinion, and one of the reasons why they found that there was an improper delegation from Congress to the SEC was there was basically, they said, you handle everything and you have complete authority. They were given absolute discretion. And the Fifth Circuit seemed to focus on the absolute discretion to constitute the improper delegation. In other words, there was no rules provided by Congress. You should do this, this, and this. It was just, you handle it. So I'm wondering if the flip side of that is, if they found that that they were provided too much discretion without rules, could that be a means for attacking their immunity? So as we know, FINRA has asserted immunity, and the SEC too, from their delegation of responsibility from Congress. But I'm wondering, if they weren't given orders and they're acting basically on their own, do they lose that? Can they lose potentially that immunity? Will ongoing matters be impacted by this? In other words, will ongoing enforcement actions be either stayed or done differently because of this pending Supreme Court case? And, for example, if I'm FINRA holding enforcement proceedings against GTI, for example, and I'm just speculating here, even though I'm sure everybody involved in that case has already seen this opinion. In fact, it looks like GTII may have based their argument based upon the ruling in the Fifth Circuit, period. But if I'm going to do, and by the way, GTII I think is somewhat different than this for various reasons, but even though there was a cease and desist order in GTII, there is currently a violation of the cease and desist order, which necessitated the current proceeding. And if we isolate it to the cease and desist order, that doesn't involve the civil penalty, and the fact that there's no civil penalty seems to separate this from GTII. But that's just me thinking out loud. But if I were going to do the proceeding that they started, and in terms of the remedies I was going to seek just to cover myself, I would not seek civil penalties. So I could see seeking relief for a violation of the cease and desist order, for imposing perhaps a receiver, or shutting their doors, or putting somebody in charge, opening their books and records, anything like that. But the civil penalties might be impacted by, or could be impacted, or at least a claim could be made that they could be impacted by this particular case if the Supreme Court rules in their favor. So I might kind of change the relief I was seeking and make sure there was no monetary relief, and I was only seeking basically to put them out of business. And in the meantime, it also, this is just me talking, if I were like FINRA or the SEC, I would go in the federal court and seek the introduction and imposition of a receiver to take over the business of Alpine, and we're talking about Alpine, and seek to enforce any contempt violations per the cease and desist order, because the public welfare is at risk. And that's just me thinking out loud. And again, I think the situation for GTII is dissimilar in the ways I asserted, because of the violation of the cease and desist order, because of the public risk, and because of the 35,000 specific violations. But it's interesting that this Supreme Court case, I'm sure, will be asserted at some point in time by either the SEC, FINRA, or parties challenging the jurisdiction of those tribunals. This is all preliminary, and the Supreme Court may rule in an unexpected manner. They may rule against and for the SEC. We don't know. But however, it appears they're trying to pull back on the authority of governmental agencies. So only time will tell. Perhaps in my appeal against FINRA, I will raise this case. I thought about that, but I haven't really had a chance to kind of ponder it. But remember, this is kind of important, notwithstanding whatever I just said about perhaps limiting federal agency power and authority. For the MMTLP crowd, GTI crowd, Finger crowd, AMC, etc., by crippling FINRA and the SEC without substituting anything that provides fair oversight, that's not a productive outcome for us. I know there's proposed legislation in Congress that is intended in part to get rid of Gensler and to reduce his power, but it also creates a committee of, I think, 6 people that'll be basically stuck. There'll be 3-3, and they won't be able to conduct or agree to matters or regulatory matters. And that's not helpful for retail traders. For retail traders, we need proper regulatory activity. We don't need overreaching. We don't need underreaching. We need proper regulatory authority. So to the extent that this Jarkesy case limits regulatory authority, we should be careful, and we should call for proper regulatory authority to protect retail investors and others similarly situated. Now, again, this was my first blush at this particular case. It's brand new in terms of that was going up to the Supreme Court, at least to my attention. And I just glanced at it, but those were the issues that popped off to me. And it'll be interesting to see if the Supreme Court does limit the SEC's power, orders that all enforcement actions have to have a jury trial, and any other such restrictions. And obviously, I'll keep you updated. And like I said, there'll be a live stream, I think, with JR, perhaps Big JR, later in the week, and we may just kind of opine and speculate about all this. This is all speculation at this point, not legal advice. I'm not a constitutional scholar. I wasn't involved in litigation. We don't know how it's going to turn out, but just kind of off the top of my head and after discussions, these are kind of some of the issues that played out. Have a happy 4th. Be well. Take care.